and I teach here at the law school, and I co-direct the Rappaport Center for Human Rights and Social Justice with Neville Hode, who is speaking. And it's my great pleasure to welcome you to Mónica Jiménez's book talk on her recently published Making Never Neverland, Race and the Law and the Creation of Race and Law and the Creation of Puerto Rico. And I assume she's going to tell us about that cover. Or someone can ask. I'd like to begin by recognizing that we're meeting on the indigenous lands of Turtle Island and acknowledge the American Indian and indigenous communities who have been or become a part of the lands we call Texas, including the Alabama Coshada, Caddo, Carrizo, Comacuto, Cuiltecan, Comanche, Kickapoo, Lipan Apache, Tonkawa, and Isleta del Sur Pueblo. It's really special for me to introduce Professor Jiménez, Assistant Professor of African and African Diaspora Studies here at UT. And I said I would just take a quick poll of the room. So how should we do it? Should we ask if you're in the law school or if you're not in the law school? So if you normally reside in this building, if you're a law student, raise your hand. And if you're not, wow. Okay. So great. This book is meant for an interdisciplinary audience, and so it's terrific to have you all here. So Mónica is the author of scholarship exploring the intersections of law, race, and empire in Latin America and the Caribbean, including this remarkable book, which we'll be discussing, which was published just last year by the University of North Carolina Press. Mónica Jiménez is affiliated with several departments and centers across campus, including the Rappaport Center, and she serves on our steering committee, but that's really only part of the story. Monica's been here since the beginning of the Rappaport Center, and that wasn't just 5 years ago. We're celebrating our 20th anniversary gala. This is not to make any of us feel young. But it means that she's been very important to the work that we've been doing. I was remembering back, like researching for conferences, including on Indigenous and Afro-descendant rights. So a lot of the work that you see here was already manifested in Monica's interest. So she was a law and law student when she did so much work for the Rappaport Center originally. I did have the privilege of having her as a student and a research assistant. I think then and even after we graduated. And at that point, she had come across, and I just learned that Professor Levinson had also recently come across the insular cases that define Puerto Rico's relation to the U.S. And Mónica later pursued that interest by deciding not to be a lawyer after being a lawyer and coming and doing her PhD studies in Latin American history and has really been working on many of these issues ever since. But it's not like they've stopped. I mean, it's been really hard. Like, I don't know when you decided to stop the book because there have been so many twists and turns of the legal, political, and economic status of the islands vis-a-vis the U.S., but within a long durée of U.S. imperialism that seems to have some unfortunate logic. And I will say that rereading the book in the last few days, like I thought of Puerto Rico very much as having been the minor and the canary, as Montgomery and Gerald Torres talked about it, because I just would see all kinds of similarities to other things that are happening in the United States today. It's only fitting that Professor Sandy Levinson, who is one of the professors who did have a hand in shaping this project's early beginnings, even if you didn't realize it, will serve as a respondent. Professor Levinson holds the W. St. John Darwood and W. St. John Darwood Jr. Centennial Chair in Law. He's also a professor in government and is one of the country's leading and most prolific, and I want to say those aren't always the same, so most prolific and leading constitutional law scholars in the country. So Mónica Jiménez will speak for about 25 minutes, then Sandy Levinson will give a response for a few minutes, and then we'll have time for Q&A. And I think most people have had the opportunity to receive, if not fully read the introduction. So please join me in welcoming.
Everyone, thank you so much for being here. I am really thrilled and moved. It's going to be too tall for me to be here today. So as Karen mentioned, I was once in your shoes. I was once a law student here and a master's student in the law and a PhD student. And I have to acknowledge Karen and Sandy because they really were here at the beginning. And I was really pleased to see so many law students here because when I was a law student here, I don't remember ever seeing anything about Puerto Rico anywhere, not at LUS, where I was one of two Puerto Rican students who were sort of arguing for why we should care about Puerto Rico, and certainly not in the law school. And so when I discovered these cases, and I was like, nobody's writing about this, and this is like wild. I also discovered the one person on this campus who knew anything about the insular cases, and that was Sandy Levinson, who'd written a piece in a very important volume called Foreign in a Domestic Sense. It's an edited volume about the insular cases that some of you might have encountered, edited by Christina Ponta-Kraus. And in that piece, he argued for the insular cases being a part of the sort of American legal canon, right, and how we should be studying them. So I'm pleased to hear that he is teaching them, but also that there are more law professors in other universities across this country who have taken up that call and are studying these cases, which have unfortunately much relevant today, perhaps more relevance today than they have in a long, long time. And so thank you all for being here, and thank you to Karen and Sandy for being here with me to discuss this. Okay, so I will talk about the cover in the Q&A, and I'll tell you why this cover, and yeah, we can talk about that. Okay, so I want to kind of start what I'm gonna do today, and hopefully keep it time, and Cooper will tell me what I'm going over, is just kind of contextualize the book a little bit. And so I'm going to put this up. This is the late, great Ruth Bader Ginsburg in 2016 in oral arguments for a case called Puerto Rico v. Franklin California Tax-Free Trust et al. And in this case, the US attorneys are arguing that, and the attorneys for a series of banks are arguing that Puerto Rico cannot pass a bankruptcy law to address its financial crisis, right? So Puerto Rico can't pass its own law, and it also can't access federal bankruptcy law. And so the lawyer for Puerto Rico is arguing that no, we should be able to pass our own law because we are not a state, which is the prohibition against passing your own bankruptcy laws, that states can't do this. And the lawyers for the banks are saying, no, Puerto Rico can't do that. It can't pass its own law, but it also can't access federal bankruptcy law. And so it's stuck. And RBG says, but why would Congress put Puerto Rico in this never-never land? Why in the world? What explains Congress wanting to put Puerto Rico in this anomalous position? So this is 2016 at the height of Puerto Rico's debt crisis, when for many people, certainly in the continental US, they are sort of hearing something about Puerto Rico displaced, and that the fact that it's now in this sort of debt crisis. This is the year after I finished my PhD, which was supervised by Karen and Ben Brower, who's here, from the History Department. And so when I finished my PhD and I was watching what was happening in Puerto Rico, and I'm watching these cases go up, I am seeing a lot of resonance with 1901, which is when the first of these insular cases were passed. And I read this because I enjoy doing things like reading Supreme Court oral argument transcripts. And I'm reading this, and it's like, whoa, wait a minute. It's not Congress. Congress didn't put Puerto Rico in this anomalous position. The Supreme Court did it, and they did it in 1901. Right? And so for me, these are this very critical moment of like a legal bookend is how I see it in my mind, right? At that point, we have this 1901 moment, and here we are in 2016, and a lot of history has happened in between, and yet 1901 is here again. And so that was kind of the genesis for the book. I took some of the research that I had done for my PhD, the questions of kind of interrogating the Downs case and interrogating some of the Supreme Court precedents. And I started to think about them in relationship to this new moment in 2016 and what was happening then. And as Karen pointed out, right, it was hard to sort of put a period on the project because things kept happening. And as things kept happening, I was like, but it's still this, right? I'm still seeing these same sort of legal dynamics. And so this is what sort of what comes of the book, or the question that kind of, the moment that spurs the book. Okay, so what I want to do, I'm going to read just a few little excerpts from the book and then contextualize them a bit. And I'm going to do that for the first 2 chapters of the book, which are the legal historical chapters and are most sort of looking at this, this area of law. And then I'll talk you through what the rest of the book does with that kind of legal historical material. Okay, so the steamer Ponce entered the port of New York carrying 576 boxes of oranges on November 2nd, 1900. These oranges were the property of Samuel B. Downs, a merchant who was fast taking advantage of the commercial opportunities offered in Puerto Rico, the United States' newly acquired overseas territory. On arrival in New York, Downs's goods were intercepted and detained by George R. Bidwell, the collector of customs for the port of New York. Bidwell designated the oranges foreign goods and levied $659.35 as import tax. Downs then sued in federal court, arguing that since Puerto Rico had been acquired by the United States in 1898, it had become a part of the US, and thus taxation of goods from the archipelago was unconstitutional. This completely banal event, the arrival of tropical fruit from Puerto Rico at a port of the United States, and the levying of import duties on that fruit, led to the most important legal precedent in the history of the archipelago, and one that continues to define Puerto Rico's economic and political possibilities over a century later. I like to read that because most people don't know that this case was really about some oranges. They're like, oh, this big economic, but it really was about some boxes of oranges arriving in New York. The case of Downs v. Bidwell, among the first of the infamous insular cases, which attempted to define the United States' legal relationship to its burgeoning overseas empire, was carefully followed by private business owners, legal scholars, politicians, the media, and the public at large. Downs and the other insular cases quickly became a referendum on the United States' imperial designs at the start of the 20th century. The US Supreme Court, understanding the many interests at stake, attempted to toe a careful line in which it could allow the US government to hold on to the insular territories and reap the economic benefits therein, while also not extending citizenship or too many rights to the territories for their inhabitants. I focus on Downs because it was there that the Supreme Court famously pronounced Puerto Rico to be foreign in a domestic sense, a nonsensical declaration that continues to flummox and confuse today. It was also in Downs that the court first declared Puerto Rico to be an unincorporated territory and set it on a course of legal exclusion that continues to define it today. The category of unincorporated territory, though novel at the time, had important precedents in the court's previous decisions dealing with Native Americans and Black Americans. This moment of late 19th century imperial expansion forced the US to contend with the many mixed race inhabitants of its new territories. In the midst of Jim Crow segregation, the US government understood these subjects as decidedly not white and more Black than not. Thus, the US turned to its history with its other non-white subjects for guidance on what to do with the people inhabiting the overseas territories. I connect Downs to the logics and legal reasoning of the Marshall Trilogy and Dred Scott v. Sanford, not only because both are cited by the court in that opinion, but also because the Supreme Court in Downs engaged in a critical moment of racial formation. It relied on its previous precedents concerning racial undesirables to make Puerto Rico a racialized space and its inhabitants intelligible within the racial and legal logics of the US. This decision created Puerto Ricans as a racialized people and established the need to exclude them from the US. Within this legal genealogy, the Supreme Court carved out various states of exception, lacunae of law where the protections of the US Constitution do not apply or apply only in limited fashion, and where racial undesirables, like Native Americans, Black Americans, and the inhabitants of the insular territories, were left exposed to the whims and violence of the state. The court's decision in Downs created such a state of exception in Puerto Rico wherein the US Constitution did not fully apply, and wherein the archipelago was left exposed to the vagaries of Congress's plenary or complete. Collectively, the Marshall Trilogy, Dred Scott, and Downs form but a small part of a much larger legal genealogy of racial exclusion, and help to illustrate how the court's reasoning, steeped in ideas of settler colonialism, anti-Blackness, and social Darwinism, underwent many contortions and legal gymnastics in order to create such an exception for racial others. Okay, so that's a little piece from chapter 1. And so what I want to talk about is what Downs was, right? So you heard how it sort of came to be. In 1900, the US Congress passes what's called the Foraker Act, which was meant to provide Puerto Rico with a civilian government. So it ended the military government that had been in place for 2 years. And it also created a system of sort of economic trade, like free trade between the US, trade between the US, not free trade, as well as created a system of governance where in a kind of local House of Representatives would exist, but all sort of the upper governmental positions would be occupied by US appointees, right? So the president would appoint the governor, and the governor would then appoint the various sort of officials below him. And what Downs sort of asked, really, in the fundamental way was what was Puerto Rico and what were Puerto Ricans to the US, right? So the arrival of the Oranges sort of forced the question, how do we contend with this place now that it's become ours, right? And what does it mean that it's ours, right? So does it mean that they are now us, or does it just mean that we sort of have control over it? And so this was the question before the court. I won't go into too much of the kind of back and forth because this case was contentious and it produced several opinions. And the opinion that we call the opinion is a plurality opinion, which as law students you all know, right, doesn't mean that everyone agreed. It just means that sort of agreed on the outcome, but not on the legal reasoning. So Justice Brown sort of makes these declarations about Puerto Rico, that Puerto Rico is appurtenant to and belonging to the US, but not a part of the US within the Constitution. And when I talk to my undergrads about this, and Esteban, who was my undergrad, can attest, I often describe this as Puerto Rico being sort of like the US's sidecar, right? Along for the ride, but not controlling its destiny. It's appurtenant to, next to. It can nowhere be inferred that the territories were considered a part of the United States. The Constitution was created by the people of the United States as a union of states to be governed solely by representatives of the states, right? So again, the Constitution wasn't meant for these people, wasn't thought of as being for the territories and its inhabitants. They weren't conceived of by it. And then this, right, is one of those great money lines. If those possessions are inhabited by alien races differing from us in religion, customs, laws, methods of taxation, modes of thought, the administration of government and justice, according to Anglo-Saxon principles, may for a time be impossible. Eye rolls, which all way back on. And then this other, right, we disclaim any intention to hold that the inhabitants of these territories are subject to an unrestrained power on the part of Congress, right? Because there was this real concern that like, well, what protects these people, right? Congress can do whatever they want. And so Justice Brown says, well, you know, there's some like inherent principles of Anglo-Saxon government that will protect the territories, and they don't have to fear that Congress is going to be despotic in the territories. So this was kind of the arguments. And for me, when I was reading this case and rereading it, the way that the court talks about who the Constitution is intended for, right, really reminded me of Dred Scott v. Sanford. But then, lo and behold, this case actually cites Dred Scott v. Sanford. So I was like, oh, okay, great. So, you know, here we are with like the most reviled precedent of the Supreme Court, right? Having some relationship to this also terrible precedent of the Supreme Court. So this was the plurality opinion, and I want to give you this little tidbit because this happens in a concurring opinion, but it's actually Justice White's concurrence that gives fodder for the idea of the unincorporated territory, which is what Puerto Rico officially is today. And so at the time, there's sort of a series of legal debates about what can happen in the territories, whether the Constitution extends to it, right? Does the Constitution follow the flag? Does it extend in part? Is there some sort of something about the territories that makes it different. And this is how we kind of get to that. And this matters because in 1901, when this case was decided, concurrence plants the seed for the idea of the unincorporated territory, right? It's not in the majority or plurality opinion. But what this does is it feeds later Supreme Courts reasoning about Puerto Rico. So that by 1922, when the last of these first insular cases, right, this kind of series is decided, this becomes the primary justification for Puerto Rico's exclusion. Right, so it kind of moves from the periphery or the concurrence into the majority opinion by 1923. So whilst in an international sense, Puerto Rico was not a foreign country, it was subject to the sovereignty of, owned by the United States. It was foreign to the United States in a domestic sense because the island had not been incorporated into the United States, but was merely appurtenant to thereto as a possession, right? So here we have this creation out of nowhere of a distinction between territory that has been incorporated and those that have not been incorporated. And I'll point out that the islands of Hawaii are acquired by the US shortly before Puerto Rico is acquired by the US. And in the treaties relating to Hawaii, the language of incorporation is present, right? So there is already an idea that this might mean something. And so Hawaii is incorporated. Puerto Rico, the Philippines, Guam, are not incorporated. Okay, so I will jump ahead then. I have all these notes and then I never look at them. Always, I do this every time I present anything. Like, pages of notes and then ignore. Okay, so the book starts here, right? It starts in 1901. And then because I thought, and I did it this way because I thought a book about Puerto Rico must begin with Puerto Rico, right? Like that's what the subject matter is. But really this story begins long before 1901, right? It begins when the US is sort of imagining what kind of power it will be and how the Constitution will deal with people that are not white men, essentially. And so it really begins with the Marshall Trilogy, right? And I have actually Karen to thank for the first sort of forays into thinking about this and making those connections when I was sort of writing up my dissertation and thinking about how to kind of think about this larger history. And so I'm gonna skip reading. I'm just gonna talk these out with you guys then. So the Marshall Trilogy, how many of you guys have studied this? Wow.
How many people have had property law?
The more things, the more they stay the same. Okay, so the Marshall Trilogy is the kind of the birth of native law, right? Indian law. This is the kind of the bedrock of Indian law. And these three cases decided by under the stewardship of Chief Justice Marshall stand collectively for the proposition of Congress's plenary power over Native Americans, right? And now the kind of, I will say, please study these cases. Not only are they extremely important in terms of thinking about Native American relationship to the US, but they are fascinating and enraging, right? Because in every, except for this Cherokee Nation versus Georgia case, which is a case where the Supreme Court actually says we actually can't hear this case because the Cherokee Nation and Native nations don't have standing before the Supreme Court case. These other two very consequential cases are cases brought by white men in which the Supreme Court is deciding major questions of Native law and thus impacting Native Americans across the US without the participation of Native parties at all, right? And so these questions are, the first one is about property. Who can Native Americans alienate their title to, right? Who can they sell property to? The second two, the Cherokee Nation cases, are a kind of a battle of wills against well, really it's Georgia imposing itself on the Cherokee Nation, right? And attempting to push the Cherokee Nation out of its out of its traditional homes in the state of Georgia and really like precipitates the Trail of Tears as we studied, right? And so, but these cases are really thinking about, okay, the US is the inheritor of sort of, of Britain in North America. So so we have this sort of domain over Native Americans. How do we treat them, right? What's going to be their relationship to us? This first case, Johnson v. McIntosh, was all about sort of hangs itself on the doctrine of discovery, right? The idea that the U.S. is the inheritor of the crown, of the British crown, and thus, because Britain discovered the Americas or North America, that Native Americans within the U.S. had a relationship only with the federal government, right? So they could only sell their land to the federal government. Their title was imperfect. It was made imperfect by this discovery. Speaking really fast, aren't
No, you're good. No.
Neville's looking at me like, I'm sorry, I'm Puerto Rican. We talk. And then this Cherokee Nation case v. Georgia is a case brought by the Cherokee Nation to basically enjoin Georgia from passing laws in its territory. Georgia started to sort of very slowly impose itself and then eventually sort of take over native territory and say that this is our territory, basically our sovereignty there. And the Cherokee Nation takes this case directly to the Supreme Court arguing that they have original jurisdiction because they are a separate sovereign, right? And this is when the Supreme Court has to decide, well, what kind of sovereign are you, right? You're not a foreign sovereign, as we understand. You're not a state, right? And those are the two sort of entities that existed in the Constitution at the time. And so instead, they designate the Cherokee Nation and Native nations in general as dependent domestic nations with a relationship to the US like a ward to its guardian, right? Again, pointing to ideas of how the US will sort of treat those of different races and different ethnicities within its territory as wards to its guardian. Again, this is echoed when the overseas territories are acquired, Puerto Rico, the Philippines, and Guam. This language of guardianship reemerges and becomes very important. And then this last case was really the kind of death knell of the Cherokee Nation's resistance. It was not brought by the Cherokee Nation. It was brought by two white missionaries who were prosecuted for being in Cherokee country. And the state of Georgia required them to get a license, and they didn't get a license. And so they sort of fought this, saying that on behalf of the Cherokee Nation, saying the Cherokee have sovereignty and can make their own laws in their territory. They lost, because Worcester lost, and essentially that was the moment when the Georgia sort of took over the Cherokee territory. And so these cases stand for Congress's plenary power over Native affairs. These cases have been revisited and nuanced, right? But the proposition of plenary power still remains with us. Okay, I'm going to jump forward in time a little bit. Again, we start with Puerto Rico, we go back to the Marshall Trilogy, and then we sort of jump forward to Dred Scott. 5 minutes, thank you. Great. And as I was reading Downs v. Bidwell, I'm seeing the Marshall Trilogy, it's being cited, but also I see the language, right? The language of guardianship, the language of plenary power, the language of who has control over the territory. And then in Dred Scott, we have similar arguments about constitutionality, who the Constitution was made for, right? This is the sort of infamous case that sparks the Civil War and really brings the question of enslavement to out, it sort of explodes everything, right, that had been simmering. And it's on the one hand about enslavement and the possibility of maintaining slavery in the US, but then on the other hand, and this is the part that we study far less as law students, it's about territoriality and the powers the US has in its territory, right? Because the argument is that the Supreme Court decides that US can't ban enslavement in the territories, right? That they had passed the Missouri Compromise and they wanted to ban slavery in the territories, and the southern states and slaveholders saw this as an unjustified taking, right? So it's really a question of what can the US do in the territory. And again, at this time, the Supreme Court says that the Constitution applies in the territories, and the people that live there are subject to the Bill of Rights, and that is sort of understood, right? That the flag does follow where the U.S. or the Constitution does follow the flag, right? So these sort of older cases, to me, allow us to understand how Puerto Rico comes into being, right? We often study the insular cases and Puerto Rico and the other insular territories separated, right, as this kind of exceptional moment in this early 20th century US sort of imperial moment, but they have these long precedents extend way back, right? So in the first two chapters of the book, I'm really looking at that history, and I'm really unpacking and close reading these cases to see where are the echoes? Where do I see the language repeat itself? Where do I see the way that Puerto Rico is being talked about echoed in the ways that Native Americans and Black Americans were talked about in these previous cases? And then the second half of the book, it then takes that and says, okay, now we understand how we got here. Now let's look at what it looks like, right? So chapter 3 is really thinking about the first 40 years of Puerto Rico. How does Downs literally make way for restructuring and remaking Puerto Rico? Right? One of the projects of the US across the territories is in creating sort of proper US imperial subjects, right? And so this takes the shape of educating Puerto Ricans. The Americanization projects begin, and they literally, like, Puerto Rican children are indoctrinated, right? They're taught how to sing the Star Spangled Banner, right? My mom will still like recite things that she learned when she was a little kid, right? Because that was the way that the U.S. planned to sort of Americanize the whole of the archipelago, was to start with the kids. So kids became a subject of this Americanization project. And it's interesting because they also resisted it at very young ages, from elementary all the way up to high school. Kids were sort of pushing back against these projects, right? Policies imposed from the US about English language education, for example, or policies that refused to allow students to engage Puerto Rican history and learn Puerto Rican history, became subjects of resistance in Puerto Rican schools. So that chapter sort of looks at across society, education, health, policing. Like, there's all of these ways that Puerto Rico is reshaped, and I argue that Downs is the gateway for that, right? It allows for all these sorts of experiments that would not necessarily be as easily done in say a state of the U.S., right, where the Constitution applied fully and where people had full access to redress by the legal system. And then I moved to this very consequential moment in the mid-20th century when Puerto Rico becomes what it is today, the Estado Libre Asociado, the Commonwealth of Puerto Rico. And I really interrogate, well, what was happening in that time period, right? There was a lot of rhetoric at the time, and for any of you who study sort of international public law and the birth of international human rights law, right? This is the moment of decolonization. This is the moment of self-determination, right? That's the kind of legal rhetoric that's in the world. And so there's this real idea about, or a real question about, what is happening in Puerto Rico at this time when we're creating this status, the Estado Libre Asociado, the Commonwealth of Puerto Rico. Is this decolonization? Because that's what it's being touted as, right? That's how it's being discussed. Puerto Rico is going to be not a colony. And so I interrogate the documents, right? The conversations that happen in Congress, the ways that this is being sold to the public in Puerto Rico, but as well as how it's being sold to the US government, right? There's two sets of sort of conversations happening at that time. And really asking the question, what did this really do, if anything, for Puerto Rico, Puerto Ricans? And then chapter 5 moves us to the present, right? And to this question of, where does this end, right? Because it continues. So it talks about this 2016 moment, and it really tries to say, let's look back while we're interrogating 2016 and the way that the Supreme Court was talking about Puerto Rico, but also Congress's attempts to address the debt crisis through the passage of a very unpopular law called Puerto Rico Oversight Management Economic Stability Act, or PROMESA, as it's referred to. Yes, the promise of that. And so really thinking about how do we contend with that history, right? And I'll stop, like that's the book. But I'll say that for me, writing the book, and as Karen pointed out, it's meant for an interdisciplinary audience. It's meant for everybody, right? It's meant, I hope, that people who are not in academia will access it, because I think it's history that was occluded from Puerto Ricans in Puerto Rico, right? I've had people reach out to me and say, I didn't learn this. I never heard about this, right? And that's important, because how can we imagine a future for Puerto Rico if we don't actually know what the past entailed, right? And where we came from. And how can we really speak about what it is, you know, to power, if we're interested in speaking to power, if we don't have the tools of what it actually was, right? So I'll stop there, and I know we are going to hear from Professor Levinson, which I'm excited to hear from him, but also a little nervous to hear from him. But thank you so much.
There's a lot to cover, and certainly not enough time to do it. First thing, one of the things that Jiménez is exposing is the dreadful inadequacy of legal education at all law schools, including most certainly elite law schools. Though what she's also talking about is the canon. And all disciplines require canons because there is not enough time to teach everything. So whether you're talking about a course in world literature, Western literature, American literature, fill in the blank, whatever the title of the course, and indeed it might be quite narrow in certain ways, choices are going to have to be made, and things will have to be excluded. And so what she is referring to is the exclusion, generally speaking, from the canon of cases dealing with Puerto Rico, indigenous nations, and indigenous nations especially. It is no longer true with regard to race, where race is defined particularly in terms of black and white relations. There has been a transformation in the canon over the last 50 or 60 years. But with regard to the others, it is still pretty much as she describes it, and it's unfortunate. Now, I will say that I'm co-editor of a case book that does include the insular cases. Why? It's because Christina, now Ponsa Krause, who's then Christina Burnett, was a student at the Yale Law School. She organized a remarkable symposium in 1998 on the 100th anniversary of the Spanish-American War. She had the brilliant idea of especially inviting editors of case books precisely because none of them mentioned the insular cases. I had never read the insular cases. I went to Stanford Law School, never read them, never taught them in what was then 25 years or so of teaching constitutional law. It was simply a blank. It is Christina who introduced me not only to the cases, but who persuaded me that they really ought to become part of the canon. I wrote an article to that effect, and our case book includes about 12 pages or so on the insular cases. Question, it doesn't guarantee that anybody uses the case book actually teaches that. Because, and this is a serious point, our case book is a doorstop, and I don't teach everything in it. And we've also excluded lots of things, so there's nothing in the case book on contemporary First Amendment, for example. I wrote an article a number of years ago explaining why I don't teach Marbury versus Madison, which I deeply think is a waste of time. It's a waste of time because of opportunity cost. It takes up time and space that I prefer to use teaching Grigg versus Pennsylvania and Dred Scott, and also the insular cases, quite frankly. But again, choices have to be made, and a lot of people are startled by the idea that Marbury versus Madison is a trivial case that no serious adult really needs to spend time thinking about, as against, say, the insular cases. So canonicity is absolutely central to the notion of academic disciplines. It's never going to go away precisely because of the problem of scarcity, scarcity of time, scarcity of resources. And so we are engaged in a political Darwinian battle to see who survives and why. And there are a lot of very interesting questions, including political questions, as to why one ignores certain cases and highlights others. One answer is that the legal profession, the people who organize the legal profession, the people who organize American legal education, by and large prefer happy endings. And given that law schools really are controlled by political liberals, conservatives are correct in that description, we are today, by and large, children of the Warren Court, which was taken to supply a whole host of happy endings. And not surprisingly, it was the cases of the Warren Court that beat out other cases in the competition for scarce time and attention. You have to realize that there's something problematic about professional education that didn't regularly provide happy endings, whether they're cures for diseases or happy results to very deep conflicts about the meaning of justice and injustice. If you dwell on the cases that I increasingly tend to dwell on in my own teaching, there aren't very many happy endings. And that raises real questions of why do you want to become a lawyer? Or why would you have necessarily any respect for the Supreme Court, for example, which throughout its history has been much more an agent of injustice than the guardian of what we would like to think. There was this one happy brief period called the Warren Court, but Earl Warren has left the building long ago. To focus on the Warren Court as typical of what the Supreme Court has done is just a dreadful, dreadful mistake. So that's one set of comments. The other thing, I want to put in a half of a bit with Dred Scott. Dred Scott is the most reviled decision in American history. I actually give pride place to Pritt versus Pennsylvania, which I think is even worse if one is talking about race and slavery. But Dred Scott, which goes on forever, it's probably the longest major opinion in the canon, very rarely taught, except to be denounced. But in fact, it is thoroughly Janus-based. What is reviled and properly reviled, I don't have a single good word to say about Tawney's conclusion that Blacks were excluded from the American political community and had no rights that whites were bound to respect. There is no defense, no defense whatsoever for that, except that Tawney was no dope. And Dred Scott is the first great originalist decision in which he said, I'm not supporting these dreadful outcomes. It is the framers who were white supremacists and created a basically whites-only society. And of course, that is a topic of huge debate even today. And the embarrassment is that if you want to sign on to the 1619 Project about the deep nature of American racism, Dred Scott is actually a very good source for quotations and arguments going to the issue, this is who we were in 1787, and Roger Tawney's role as judge was to be the faithful agent of the vaunted framers. But that's actually not what makes Dred Scott most interesting today. It is precisely what was mentioned. That is, Dred Scott stands for the proposition that the Constitution follows the flag. Now, what is dreadful is that Tawney said this just meant that slave owners had a constitutional right to take their lawful property with them into the territories. Dreadful, dreadful, dreadful. But what's so interesting, and one of the reasons I really became riveted about the insular cases after Christina led me to read them for the first time after roughly 25 years of teaching this stuff. What I found fascinating is that it was the majority opinion that tried to duck Dred Scott. It was the dissent by John Marshall Harlan, the great dissenter in the civil rights cases, the great dissenter in Plessy versus Ferguson, who says, you know, what Dred Scott stands for is that the Constitution follows the flag. The United States is not an imperialist power that is entitled to have colonies and treat the inhabitants of the colonies however it wishes. That, in essence, is what the European imperialist powers do, but that's not what we are about as Americans. If we want to have colonies and territories, we have to pay the price of realizing that the inhabitants of those colonies/territories have every right that every other American does. That's not obviously what the majority held. They invented out of whole cloth the notion of unincorporated territories, the impertinent territories, but they really had to duck Dred Scott. As I say, what makes Dred Scott so fascinating is that Tawney really and truly believed that the Constitution did follow the flag. He also really and truly believed that if you're an American citizen, you got a whole bundle of important rights. One of the things you discover after the 14th Amendment, which is said to have overruled Dred Scott in one important way, which it certainly does, by establishing birthright citizenship, which incidentally didn't apply to the people of Puerto Rico. Puerto Ricans are not birthright citizens due to the 14th Amendment. They're citizens due to the Jones Act of 1917. And for constitutional theorists, that raises the question of whether Congress could just repeal the Jones Act. Why not? This also raises certain exotic questions if you've now gotten interested in Greenland and possibly founding in America as well. That's 11 minutes, 2 seconds, so we can try to wind up. But after 14th Amendment arrives, the blacks become citizens. Lo and behold, one discovers that the United States Supreme Court basically leaches out many rights of citizenship that Tawney, in fact, recognized. In fact, it's very difficult to figure out exactly what you get when you're an American citizen. And that remains a question even today. So, I would say not that one ought to admire Dred Scott, it's certainly not the case, but that like many cases, it's really worth reading for its complexity and its ambiguity. One of the reasons, I will end with this, there is an ideological interest in viewing Tawney as a rogue judge, a simple racist slave owner, who incidentally, he was a slave owner, he manumitted slaves, unlike, say, George Washington or Thomas Jefferson while we were alive. But we want, as I say, we want to demonize Tawney. One of the reasons I think we ignore Prigg, which, as I say, I think is a worse decision, is because Joseph Story is not Tawney. And in fact, there's a wonderful statue of Joseph Story that you see as you enter the library of the Harvard Law School. He is not a demonized figure. But what one wants to do is to view him as a justice on a rampage. Dred Scott is merely a group of runaway judges who have nothing useful or interesting to tell us, as against the possibility that in some deep sense, William Lloyd Garrison was right, that the Constitution was a covenant with death and an agreement with hell, and that both Story and Tawney were faithful executors of the Constitution created in 1787. That's much scarier to contemplate than simply to treat Tawney as the rogue justice on a rampage and to view Dred Scott as if it has nothing interesting to tell us about the American constitutional order, not only for ill, but also this valorization of the Constitution, following the flag, and the fact that if you're a citizen, you really get a genuine bundle of rights, which is why it's important to exclude certain people from becoming citizens, because one of those rights was the right to keep and bear arms. And I think it was unthinkable, and not only to Roger Taney in 1857, that Black Americans, any Black Americans, had a constitutional right to keep and bear arms. But Roger Taney said every American citizen has the right to keep and bear arms. That's just what the Constitution means. And of course, that continues to be a very, very live issue today. I wish we could go on to 3 or 4 o'clock to discuss this really fascinating book, but it's very, very much worth reading.
We have till about 12:50 before we're supposed to vacate the room. So Monica, if you want to maybe.
Yeah, I want to answer Aaron's question first about the cover. That image. So I so this is a mural that was on a building in Puerto Rico, and it's called People Before Profit is the name of the mural, the piece of art. And it's by a graffiti street art collective called Bemba PR. And they make art that speaks to the kind of the moment, right? So to the economic crisis, to gentrification, to the loss of erosion of land through erosion and climate change. And I knew that my book was going to be called Making Never Neverland because I just thought, wow, that is like, thank you, RPG, right? Like that's such an amazing characterization of this place that has been put in this sort of position, right? And a friend of mine sort of extolled me to explain what I mean by Never Neverland. Does that mean that Puerto Rico can't ever move out of that status? And so I want to be very clear that that's not what my belief is, right? My belief is that through these legal structures, Puerto Rico finds itself in this sort of untenable position that from the kind of federal structure, it cannot move out of. But that doesn't mean that people can't find ways to make their own sort of lives and their own futures within that structure and to resist that structure, which is what is happening in Puerto Rico and has been happening in Puerto Rico. So I want to say that, but I also just thought it was a remarkable kind of way to characterize this. And I wanted an image that was as sort of startling and surreal as that concept was. And I had the chance to work with Bemba PR on a different project, on a fellowship. And when I saw this image, I was like, can I use it? And they very sweetly said, yes, of course. And so here we are. And it's funny because people ask me why, and I've also had people who hate it, and they're like, your cover needs a new cover. Yeah. But I love it. And so I'm glad that it's a source of conversation. So anyways, for Karen. Yes.
So I come from Latin America. I haven't read the book, but it sounds that I have to. Your first 2 chapters appear to be more about US than Puerto Rico. What is the legal resistance in Puerto Rico? What is the agency of the legal world in Puerto Rico? And Puerto Rico, as with a foot in the US and a foot in Latin America, Dred Scott was never accepted as a legal doctrine in Latin America. No court would ever say that.
Yeah.
The racial relations in Latin America are completely different. So what is happening in Puerto Rico in terms of legal terms resisting
Yeah.
this?
Thank you for asking that. So part of I always make it explicit that I position Puerto Rico as a Caribbean site, as a Latin American site, and as a US American site, right? It is all of the above. And thus it is sort of experiencing various parts of those sort of societal norms, historical norms, race structures, right? So what I find interesting, and I do talk about this a bit in the book, is that when the US arrives with its notions of race, right, there is already a racial sort of, there are already racial understandings in Puerto Rico that have developed over years, right? And so it's this really interesting moment of like tension and also of accommodation and how do these things play out, right? But then there's the federal kind of and legal superstructure that is also being placed upon Puerto Rico, even while people in Puerto Rico are sort of sometimes adopting it, accommodating it, resisting it. And there are, especially in that early 20th century moment, a lot of alliances between Puerto Rico and Puerto Rican political thinkers and would-be politicians who are looking to other places in the Caribbean and in Latin America, right? For allyship, for potential, revolution, right? So that Puerto Rico in that moment, especially, and still today, sees itself as part of Latin America and as part of the greater Caribbean, right? So it's hard to sort of, it's not clean, right? The way that this kind of works out in terms of adopting US law or US law being imposed. There is still this kind of, to this day, this civil law and, federal law system. And in fact, when the US arrives, one of these insular cases is really about, do we impose our common law or do we keep the civil law, right? Are they ready for common law? Shouldn't we let them have civil law while we transition? And some of that transitional moment just went on and on and on and on, right? So there is still this kind of a little bit of an amalgamation of legal systems. But it's really important to me to talk about Puerto Rico as a place that is at once US history, right? So when I talk about this book, I say US history, it's Caribbean history and Latin American history. It's also Native history and Black studies, right? It is all of these things because Puerto Rico is all of that stuff, right? And this history touches on all of that. So thank you for that question. Yes.
I'm only recently an American and I'm not a lawyer. But hopefully those two disavows can be enabled. One, Never Neverland. I mean, I don't know, this is where in the childhood reading unconscious of RPG. Because it's J.M. Barrie's Peter Pan and Never Neverland is the place where you go where children can fly and they never grow up. So I wonder if you riff on that at all. So
yes. And so I thought about the title. I thought was great because everybody's heard of Never. And we all know Peter Pan, right? Or at least we have a notion of Peter Pan, even if we haven't read the book or, right, we've seen a film, whatever. We've heard that term and it brings something to us, right? So when you see it in this context, you're like, well, what does that mean? Right? What are we saying? Is it a place where people fly? Or is it just a place that's kind of where people don't grow up, right? Which is what Never Neverland also was, right? Where the children don't grow up. And so again, I'm not saying that Puerto Ricans don't grow up and that Puerto Rico doesn't grow up, but that it is in this like stasis, much like Never Neverland, right? The J.M. Barrie's Never Neverland. And that is not created by Puerto Ricans, right? That wasn't created because of something that people there wanted. Anyways.
And then the other one is, in your last answer, you listed all the kinds of places, historiographies, geographies that Puerto Rico is part of. And then earlier in your talk, you said the word settler colonial. And as I was listening to you, this is where the I'm only recently American comes in. A lot of this sounds like British indirect rule. A lot of it sounds like various configurations of native sovereignty across the British Empire. So I think it's also so, and then when you got to the decolonizing moment, there is some kind of global consciousness there. So I suppose my question is, of course, Puerto Rico is a singular place with a singular history. But when you hit those decolonizing chapters, and I'm ashamed to say I haven't read the book, but I'm dying to. I mean, who are the decolonizing people that the Puerto Rico people are reading, interacting with? Like when in this moment does this story become global and cosmopolitan? My question.
Yeah, I mean, so there are moments, right? And the way that I tell the story is through like these discrete moments, right? Because as you saw, it covers a lot of historical time. So I can't tell the comprehensive history. So I sort of jump in these moments that I see as sort of legally important. But certainly the like early, I would say first 30 years of US rule of Puerto Rico are time when Puerto Ricans are thinking with, talking to, in conversation with other intellectuals in Haiti, for example, in the DR, in New York, right, in that like nexus of Caribbean and Afro-American and Afro-Caribbean thinking. Right, this is when we get Schomburg, who is one of these people who's moving in this like transit of empire. So that there is very much a vibrant history of Puerto Rican intellectuals thinking across geographies. And then certainly in that mid-20th century moment, there's a conversation that is happening across the Caribbean, right? That is inclusive, the British Caribbean and the French Caribbean. And that is very directly looking at the British Commonwealth, right? And how did the British Commonwealth come to be? And could that be a model for what Puerto Rico becomes, right? Commonwealth's nations. So it is very much, and again, because I look at it in these discrete moments, they're sort of parts of a larger historiography of how this is happening. But Puerto Rico, I think, is often accused of insularism, right? Because it's such a small place. It's like, you're sort of looking into internally. But I would argue that throughout certainly this kind of US colonial period, there's always been conversations. And then, of course, there's always been conversations with Puerto Ricans and Hawaiians, right? Experience that in very similar ways. Not the same, but there's similar dynamic there.